Welcome to our Stress at Work 2022 seminar. I'm Nicholas Lakeland. I head up the employment team here at Leighton's, and this is my colleague Victoria Brockley, who's a partner in the employment team as well. Why a focus on stress at work? We've had the 2 years of pandemic, which caused a lot of psychological issues for employees, and we are about to enter into a period of recession, which if we are to believe what we're told, is going to cause further stress and anxiety to employees. Hence, this is a really rather important topic for us to look into. We know that HR professionals are often faced with fit notes that have the 3 magic words stress at work when signing off an employee due to ill health, and we are well aware that those 3 words are loaded with meaning. Statistics tell us for 2021 that 822,000 workers suffered work-related stress, depression and anxiety. That comes from the Labour Force survey and is cited on the HSE website. The CBI states that £4 billion is lost every year through anxiety, depression and stress at work, and 30% of all absences from work are caused by stress. Clearly, stress affects productivity and therefore hits the bottom line. What is stress? The Health and Safety Executive defines stress as the adverse reaction people have to excessive pressures or other types of demands placed on them. The World Health Organization defines stress at work as the response people may have when presented with work demands and pressures that are not matched to their knowledge and abilities and which challenge their ability to cope. Just to emphasize how much focus there is on mental health issues, there is even a World Health Organization definition of burnout. HR's role in identifying stress or mental health issues is therefore vital, because they are able to monitor and absences, failures to take holidays, lack of engagement or performance. All of these are signs of potential stress, and it is therefore crucial that HR have their eyes and ears open for what may follow.
In the context of this talk on how to manage the stressed employee, it's important to understand the potential claims that the stressed employee can bring and flag up these litigation risks for the employer. Employees have rights in contract and they have rights in statute. They have rights against the employer they work for, and they have rights against the individuals they work with. One of the claims that the stressed employee may be able to bring is discrimination on the grounds of disability. If their stress condition meets the statutory definition, they may be able to claim that the treatment that has been discriminatory. There are uncapped damages for successful claimants of discrimination claims on the grounds of disability. Personal injury claims can also be brought where the employer breaches a duty of care. This is often linked to health and safety and working hours. A stressed employee may decide to resign and claim that they've been constructively unfairly dismissed if the treatment afforded to them is considered by them to be so bad that it breaks the implied duty of trust and confidence of the employer. Employees who are stressed may also make a claim for breach of contract if they have a claim about something their employer ought to have done. There may also be a claim for protection of harassment as a standalone claim under the Protection of Harassment Act. And finally, it's worth considering and probably looking at in further detail another time that the issues of breaches of confidentiality and claims that the employee may be able to bring about their employer's use of their medical evidence and medical information about their stress condition, which is special category data. The employee whose stress is heightened, their emotions are heightened, and you need to really consider that there is a lot of mud that they're able to sling. The next issue to consider is, are they stressed or are they actually disabled? The definition of disability is found in the Equality Act, and the way to consider this is that if an employee is stressed, they're on a path, and down the road on that path can lead to the definition of disability. The Equality Act prevents discrimination on the grounds of disability, and there are 4 elements to the definition of disability, which is an employee with a physical or, in this case, mental impairment, which is substantial, which affects the employee's ability to carry out day-to-day activities which last for 12 months or is likely to last for 12 months. And it's the employer's knowledge of the disability which is key to whether there's been any discrimination. An employer is expected to do all it can to find out about the employee's condition, and medical evidence is usually sought by way of doctor's letters and also occupational health reports. The fact of stress puts the employer on notice that there is a problem, and this could be a precursor to a claim for disability discrimination.
I'm now going to turn to health and safety law. For employment lawyers and HR professionals, health and safety law is unfamiliar terrain where familiar employment rules do not apply. The key statute is the Health and Safety at Work, etc. Act of 1974, and the Act imposes a general duty on employers to ensure, so far as reasonably practicable, the health, safety and welfare at work of all their employees. The significance of the statute is that if there is a breach of duty and of the statutory requirements, the employer faces potential prosecution. The sanctions are criminal and therefore are either dealt with in a magistrate's court or a Crown court. HSE investigations are extremely detailed and taxing for any employer who's facing them, and are usually carried out under the auspices of the Police and Criminal Evidence Act. Therefore, interviews under caution take place with those being recorded, usually at the Health and Safety Executive's offices. The HSE has a very high success rate of prosecution, and 85% of cases prosecuted result in a conviction. In accordance with the Health and Safety at Work Act, there is then the requirement under the Management of Health and Safety Work Regulations to carry out risk assessments. One of those risk assessments relates to health and stress and anxiety and mental well-being. If one looks at the standard document produced on the HSE website, stress is a risk factor, and therefore it is a matter that employers have to take into account when assessing the risk to employees. The HSE will require an employer to conform with principles of prevention. Employers are required to avoid risk, combat risk at source, develop coherent and overall prevention policies which cover technology, organisational work, working conditions, social relationships and working environment, and employers are required to give appropriate instructions to employees. These risk assessments should be practically implemented and regularly reviewed. An employer has to demonstrate good practice through a step-by-step risk assessment approach. Employers should use pre-existing data, surveys and other techniques to assess the health and safety, and in this case, the stress and mental well-being of their employees. The HSE helps employers by providing a stress indicator tool, workbooks, guidance, and videos, all of which can be found freely available on the HSE website. The intention is to always identify the main risk factors, help employers focus on the underlying causes of the risk, and aid prevention. It's important that senior management engage in this process. This is not something that is just for HR or a health and safety professional if they are employed in the business. This is a matter that has to be taken seriously at every level of the business. The HSE management standards have 6 key areas that they require employers to consider: demands, control, support, relationships, role and change. These are detailed on the HSE website, and I would urge anybody who's looking at this area to read the HSE website and its contents. What do they mean by demands? Essentially, can the employee cope with the demand of the job? Is the workload too much? Are the working patterns appropriate? Is the working environment appropriate? Can the employee correctly perform that job given the skills they've got? Should they be being trained? This all conflicts with an employer's requirement that the employee perform their duties during set hours. It effectively challenges that contractual position. Control. The HSC talks about employees being able to control their work and control their work patterns and be consulted about them. Again, that is in direct contrast to what an employer requires, which is the employee to perform their role for a set period of hours. Support. An employer is expected to support, encourage and train their employees. Relationships. An employer is required to create a positive working environment and provide employees with means to complain about unacceptable behaviour, and requires employers to deal with that unacceptable behaviour. This is in contrast to employment law, where a grievance would perhaps be brought by an employee, leading to another employee perhaps being disciplined. This is a requirement that means that the employer is required to look at the behaviours that are not even being complained of, but look at behaviours that are in fact inappropriate and deal with them irrespective of whether they're being complained of. Role. It's important that somebody is able to perform their job and are in the correct role. They either have the right skill sets or they are taught to have those skill sets so they can perform the role adequately. Change can cause a great deal of uncertainty for employees, and it's very important that employers take this on board and understand that timetabling, warnings, being able to inform employees fully as to what's happening when is part of what is required.
There was a seminal report published between the Department of Work and Pensions in coordination with the Department of Health, which was called Thriving at Work, and this report looked at the correct ways to view mental health, and this is obviously a very useful report to consider when managing the stressed employee. The report says that we all have mental health. We fluctuate between thriving, struggling and being ill. And the vision of this report, back in 2017, is to remove the stigma of mental health and allow for the employer to positively contribute to the mental health of their employees. And there are 6 core principles that the report describes and discusses for helping employees with their mental health at work. An employer should have a good mental health at work plan. They should develop mental health at work awareness, encourage open conversations about mental health and the support available when they see an employee struggling. Employees should be provided with good working conditions, and employers should promote effective people management, and everything should be routinely monitored with regards to what's implemented and the employee's well-being. The focus of this report is on the general intent and attitude and practical application of providing the employees with support. When considering practical support for the stressed employee, the first suggestion from us is to get a good policy in place, a stress and well-being policy. Review the policy, discuss the policy, trial the policy and review the policy again. This policy should start by explaining what stress is, what mental health is, and we suggest having a distinction between working under pressure and experiencing stress, making clear that certain levels of pressure are acceptable to help improve performance, enable individuals to meet their full potential and provide employees with a sense of achievement and job satisfaction. A distinction must be made between the difference between pressure, which provides for strong performance and job satisfaction, and pressure, which can cause stress and harm to the employee's mental health. In a stress and well-being policy, it's important for the employer to explain what they're going to do, to explain that the culture is of open communications and that there are formal and informal ways of relaying information about mental health concerns. The policy should explain that how monitoring takes place and when there will be risk assessments. The policy should also explain when training is going to be offered and the support that will be given by occupational health and employee assistance programs. Quite simply, stress and well-being policy is probably one of the most important policies for an employer to have in their handbook in 2022. Further considerations to help give practical support for the stressed employee are looking at the involvement of a number of people. This is not just an HR issue. Mental health champions and mental health first aiders should be included and introduced and should help the stressed employee. Mental health champions and mental health first aiders are not the same thing. A mental health champion's role is to raise the issue of mental health, the awareness of mental health, to promote the awareness of mental health, seek thoughts from the staff and offer support, driving change and taking responsibility. Mental health first aiders are different. They're a member of the workforce who are trained to recognise signs and symptoms and guide the employee towards support. It's important to carefully consider the selection of a mental health first aider. They need to be robust, preferably without stress, worries and mental health issues of their own. And it needs to be made very clear that they are there as a guide only. They are not to be supporting the stressed employee outside their own working hours. They are not to provide their own personal telephone number, their own personal email accounts. This is part of their role as an employee themselves, and we need to ensure that they are also supported. It's important to consider that there is a petition for mental health first aiders to be made mandatory and a legal requirement for employers. That hasn't actually come into law yet, but we expect in the next few years that it may be in law and a legal requirement in the same way that an employer has to have a first aider to help with physical injuries. Employee assistance programs are available for employers to support, give counselling and provide well-being information to employees. Lots of employers have these employee assistance programs now, and it's important to make all employees aware about this and regularly update them about it. It's no good sending them one email at the start of their employment. Regular, weekly, bi-monthly rather, information reminders should be given to employees about where they can contact, how they can contact the employee assistance program and where the details can be found, perhaps in your internal newsletters, for example. Occupational health is a really key tool for an employer to use to support the stressed employee. And employers shouldn't consider occupational health as only being available for disabled employees. This is a tool that can hopefully help manage and help the employee relieve their condition and hopefully not then become a disabled employee per the Equality Act definition. Going back to the main principles of in the Equality Act, the employer's knowledge is key, so employers should make use of the occupational health report and gather as much information as possible to be able to help support the employee who's stressed. Employers may wish to consider offering their employees a sabbatical to help have time off while their employment rights continue. If resources allow, this can be a good option for the employee to relieve stress and hopefully get better away from the pressures of work. Obviously, this is dependent on the company's resources, but the pandemic has put travel on hold, and this is often, we're finding more and more, this is actually a tool that is being used by employers. Further examples of practical support include newsletters, webinars, inviting employees to speakers, motivational speakers, wellbeing speakers, sending podcasts, sending invitations to yoga on Zoom or yoga classes or mindfulness classes. There are a number of things that can be done. Obviously, it's important to check the links that you're sending through. Obviously, it's important to ensure that they're appropriate. But reminding the employee of your support in this way can be very useful for an employer. It just needs to be consistently applied with regular communication. The final point to consider for practical support for the stressed employee is for an HR advisor to consider what their plan is, and this goes back to the core principles of the Thriving at Work report. Have you got a plan, for example? How are you promoting awareness? The questions to ask yourself relate to the core issues of the plan. How do you encourage conversations about mental health? How do you ensure good working conditions for a work-life balance? How effective are your management team ensuring that there are regular communications? And how do you routinely monitor employees' mental health in the workplace? They're difficult questions, but questions that should be asked and reassessed. The point is, you need to maintain the policies that you put in place and the working practices that you implement, and adapt to your workforce and change and see what works for you. Updating policies regularly and ensuring that communications are clear are essential.
In conclusion, it's extremely important to ensure that policies and procedures are actually implemented. It's simply not acceptable any longer to produce a set of wonderful policies, put them on an intranet or in a handbook, and just simply ignore them. Employers are now required to essentially put those practices into effect. They need to talk about health and safety, they need to talk about mental health, and that should be a widespread conversation within an employer's organisation. Know your staff, monitor your staff, be aware of what might be happening, and look out for the signs of stress and mental health issues. The consequences of failing to do so are quite severe, because the claims that arise from depression or disabilities, or even prosecutions which may in due course take place because of a failure of an employer to look after the health and safety of an employee, are all serious. They are multifaceted types of claims, they're difficult to defend, and health and safety in particular is not employment law. It is not as forgiving, and the penalties are quite severe. Thank you for watching.
Thank you.